Welcome to today's VEROSCOPE, where we're going to be looking at Judge Cannoni and the level of judicial consciousness that she has in the Karen retrial. You might be new to the Karen retrial. If you are, we're going to run through, this is Karen, by the way, and John O'Keefe there on the right-hand side. He was a Boston police officer who was killed, and there was a murder trial. Karen was tried twice. First was a mistrial, and in the second trial she was found not guilty of the murder. And this guy here, Ian Whiffen, a fellow Brit, he did a report on the analysis of various technology discoveries within the phones. And his report was thorough, extensive, and I believe fair and balanced. However, then the prosecution, someone in the DA's office, someone in the prosecution team took that report and they produced a slideshow, a PowerPoint. And that PowerPoint had on it some of Ian Whiffen's report, but it also didn't include all of the exculpatory evidence. So it included all of the evidence which aligned with the prosecutor and their narrative, but none that proved Karen's innocence. Isn't that a coincidence? So we're going to be running through the forensic linguistics and the statement analysis, and we're going to be looking at the language of the judge, Judge Cannoni, and we're going to see whether or not there is a correlation between her decisions and where it could be dangerous. I'll give you an example. And by the way, deception and lies, and gaslighting for that matter, often lives in confusion. And so if you've ever been confused about Ian Whiffen's role in this trial, the technology findings, how it all works. Oh, and by the way, Bob Alessi, who is this video for? If you're studying law, if you want to be an attorney or a barrister, if you're in, then it's very worthwhile understanding statement analysis. If you're interested in true crime and you want to get to the truth of statements, understanding how the behavioral analysis unit of the FBI analyze statements can be a very useful skill to learn. And so on the VEROSCOPE channel, and there is a membership level if you want to go into a more formal learning, but each day on the VEROSCOPE channel we do a more educational, less formal analysis of an actual trial. So without further ado, let's begin the trial itself, and we're going to watch Bob Alessi here, one of the best attorneys in the world in my opinion, along with the wonderful Yannetti and of course Jackson. What a dream team Karen had on her side, thank God. Let's listen to what Alessi is going to expose from this witness and expose from the judge's reaction. We're going to be looking in detail at the forensic linguistics of the judge, Cannoni. We're going to see how much is she aware of the danger of the truth coming out and evidence that it couldn't be Karen, she couldn't be in two places at once, evidence that John's phone moved when he was dropped off 82 feet into the house area, and magical things were happening to John's phone in the same way that the suspect's butt dials happen. That phone was moving, that phone was being opened, actions were occurring, face recognition. Did they hold the phone up to John's dead body? Either way, the prosecution have to hide this evidence. Does Judge Cannoni help them do it? And if so, only in areas where it's dangerous. Let's see. Keep a notepad handy.
Thank you, Your Honor. May I proceed with the
Yes.
administrative matters? May I approach?
Yes.
Thank you. Your Honor, pursuant to a stipulation with the prosecution, I would like to mark and enter into evidence 3 documents. These are each portions of a March 2025 report prepared by Mr. Whiffin. The first one.
So, yes, they can come into evidence.
Right.
They can come into evidence. There's a stipulation. So we can mark it as the next exhibit.
If we could, that's page 29 for the next exhibit.
You want them marked separately?
Separately, please. The next exhibit will be.
So notice that the prosecution didn't put this man's report into evidence. Instead, they changed his report into a PowerPoint presentation, conveniently leaving out all the exculpatory evidence and putting in anything that only fits the state's narrative. Is this against Brady regulations? Whiffin most likely wouldn't know that that's the case, but does he feel uncomfortable knowing that his report hasn't been entered into evidence, but somebody's slideshow, somebody's PowerPoint? I get the impression from the language, but we'll need to study, that it's not his PowerPoint. Let's carry on.
Pages 77 and 78 of the same report.
Okay.
The third and last is page 43 and page 44. May I, Your Honor?
Yes, please.
Good afternoon, Mr. Whiffin. I don't believe we've had the pleasure of meeting.
Good afternoon.
Cell phone data, when correct and when correctly analyzed, can help tell a story of what may have happened under various circumstances, correct?
Correct.
And in cases like this.
So in forensic linguistics and statement analysis, we establish a baseline of how they are, their normal way of speaking. So if you're practicing VEROSCOPE, try to establish his normal way of speaking when he's not under pressure, when he doesn't need to lie, when everything's very simple and easy, which it normally is at the beginning of a cross-examination, and notice how he is, and then notice change from the baseline.
Literally seconds on cell phone data can be significant, correct?
Correct.
What I'd like to do is to go back to your PowerPoint presentation and specifically go to the timeline that you had gone through with Mr. Brennan, and rather than repeating everything, there'll be select aspects of the timeline I'm going to reference, and with the court's permission, we will put the timeline back on that's already in evidence.
Okay.
Thank you. So what I'd like to do is to start with page 70, which we have as 78 of the deck. If you could, Mr. Wolf, go to that. And what I'd like to do, if I could please, Mr. Whiffen, is draw your attention to the very last entry, which says at the bottom, location 122438, and it indicates description, first location record showing speed of 0. Do you see that, sir?
I do.
And this is the arrival of John O'Keefe's phone at 34 Fairview, correct?
Correct.
If we could go to the next page, please.
Okay, so Alessi is going to establish that John's phone has stepped out of the car as he does. That's not in dispute. John gets out of the vehicle. And then Alessi is going to establish, using the state's own expert, what happened to that phone and where it went. And the judge and the prosecution are going to attempt to stop you knowing this. Let's see what happens.
We have up at the top 12:24:59, about 21 seconds later after arrival, we have device unlock with Face ID, correct?
Correct.
Is it possible for anyone other than John to unlock that device with Face ID?
If a secondary user was set up.
Do you have any indication that a second user was set up on John's mobile phone?
I never looked at that.
I'm sorry.
I never looked to see if a secondary user was set up.
In terms of...
By the way, if you're interested in commentary-free trial footage where you don't have people like me ruining it all, but you just have the trial, do subscribe to the trial channel, who very kindly edit out all of the waiting around and the sidebars where nothing's happening for half an hour, so that it's clean, commentary-free trial footage. Excellent, one of the best channels on YouTube to watch trials. Please do subscribe to them. And if you're in the subscribing mood and you find this presentation useful, I would appreciate a subscription too. And don't forget to like, which is the biggest signal you can send to YouTube to share the analysis with others, to extend the reach of the YouTube showing it.
The next entry, 12:25:08. It says, read message, you coming here? With 3 question marks. What I'd like to do, because you did not note who that was from, but I want to go back a few slides so we can identify.
And we know who that's from, don't we? Don't we? You coming here? 3 exclamation marks. That's from Higgins.
Who that message was from. We could go back to 76, please, Mr. Wolf. So in the last line there, message, reading left to right, 12:20:49, it says message received from someone listed in context as Brian Higgins. Do you see that?
Correct.
So if we could go back to slide 80, excuse me, if we could go back to slide 79, that phone reading the message, you coming here, is reading the message from Brian Higgins, correct?
Correct.
But you didn't note that in the timeline that was from Brian Higgins, correct?
No, I was just highlighting the fact that a message was read and that the contents of the message were you coming here.
But you didn't note in this entry, when it was read by John, that message was from Brian Higgins, correct?
Correct.
Now,
so did you notice the slight evasion there? The slight refusal to answer the actual question? Because why? Why not put in the evidence? We just leave that question hanging. Why? Why leave that out?
The next entry, lock, again, I'm always going to be reading left to right unless otherwise indicated, sir, is a time of 12:25:09. And it says, device locked with lock button.
Yes.
You see that, sir?
I do.
That requires human volitional conduct. In other words, someone has to actually manipulate their phone and hit it, right?
Correct.
Now, at this particular point, isn't it correct that in your report that you mentioned in your March 2025 report, that you had more of a description of what was happening at this time with the phone, namely, device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Isn't that what you had in your report?
Yes, that's covered in the location section of this report, the PowerPoint.
So there is no...
So we note there he's coming off baseline, which is correct or yes, to unnecessary language and explaining, and also his sentence at the end there just turned into the PowerPoint. There was no sentence structure, there was no end to it. You might have noticed that. So the PowerPoint at his unconscious level in the broker, part of the brain responsible for selecting the words that we use in language, it selected, because he's very sensitive about it, the PowerPoint. I might turn on the subtitles actually. This might make it easier to see.
Statement in this timeline under any type where you had concluded that at this time the record showed that the device was moving west from the road. And
do excuse me, I've mucked it up. Here we are.
Report that the device at this time was moving west from the roadside towards the house. Did you include it in that timeline?
No, I left that out of the timeline.
Next entry. 27.
Okay, so that's not very good, is it? I just left that out of the timeline.
7:33. That's 12:27:33. You note that there's a message received from Jen McCabe. Here, exclamation point, question mark. You see that, sir?
Correct.
Now, so what's Jen McCabe doing texting John's phone after Higgins has left his message, you coming here, exclamation mark, exclamation mark, exclamation mark. Now McCabe, everyone's interested in John arriving, aren't they?
At this point, you have two people in just 2.5 minutes, Brian Higgins and Jen McCabe, trying to find out if the John is coming to 34 Fairview. Is that a fair conclusion?
It appears so.
I'll allow it.
Is that a fair?
So we now have the first interruption by Brennan objecting, and the judge saying she will allow it because there's no basis for objecting. Higgins and McCabe have texted John. Thanks for allowing it.
Conclusion?
It would appear so, yes.
So just because of the colloquy that occurred, I want to repeat the question. Now you have, at this point, at 12:27:33, you have two people, Brian Higgins and Jennifer McCabe, in just 2.5 minutes, trying to find out if John or the phone is coming to or if John is coming to 30.
Also notice whenever witnesses start begging for objections, notice how they do that. Why?
For Fairview.
Okay. Sustained. Ask it differently, Mr. Alessi.
Thank you, Your Honor. Now, at this point, you have two people trying to find out if John...
So we'll be picking up evidence of coaching beyond Brady from Brennan, and we'll be looking at his forensic linguistics to see if there's evidence of coaching to a level which crosses the line with the witness. And we'll be able to correlate Brennan, Cannoni, and the witness to see if there is a triangle where they're all very sensitive about evidence proving Karen's innocence coming out, being shown to the jury. Is there a trifecta between the judge, Whiffin and Brennan to prevent the truth coming out. This is what we're going to see. This is the evidence which we're going to collect if it exists.
Is coming to 34 Fairview, correct?
Objection.
Sustained.
Mr. Whiffin, in terms of the information at this stage, there are two communications with Mr. O'Keefe on this phone, and that is they're trying to find, excuse me, I'll rephrase it. There are two communications, one from Jennifer McCabe and one from Brian Higgins, correct?
Correct.
Now let's go to the next deck 80, please, Mr. Wolf. This is 122745, device unlock with Face ID, correct?
Correct.
And then right under that is 122748. It says read message, which it says here, and is it correct that that is the message that was sent by Jennifer McCabe?
Correct. I'd just like to point out it says read message, not read message.
Read message, thank you. And that, the fact that Jen McCabe sent that message and that it was read was not indicated in your timeline at this point, correct?
So repeat that question.
Yes, you did not, it does not appear in that timeline that you've drafted that that message that was read was from Jennifer McCabe, is
Correct.
it?
Correct.
Next entry, 2750, device locked with lock button. Next entry down that, 2937, Doppler pocket state. And I want to be clear. Does Doppler pocket state mean that someone takes an iPhone?
Okay, notice he's stopped breathing. He's causing himself trouble. He has cotton mouth. He's aware of the problem. The problem is the PowerPoint presentation doesn't show the other half of his own report. The exculpatory parts, the parts that prove Karen is innocent. This is an extremely part of the trial, an extremely dangerous part of the trial for the prosecution, because their own witness's report has got the evidence in it that Karen is innocent. And they have to, almost like a photograph, they've had to cut it in half to only show you the bit that looks guilty. But they won't show you the other half of the photograph because you'll put two and two together. This is what someone has done. Someone is responsible for making a new PowerPoint that is entirely different than this man's report, which is fair and balanced. And he's struggling with it. He knows that his entire report hasn't been shown to the jury. But I think he's got social obligations to the prosecutor. He's struggling with it. His honesty and his morals are causing this reaction. He's literally torn.
Because up above there's red messages we went through on 2748. So if somebody reads the message and then it goes at 2937 into Doppler pocket state, does that mean someone has, for example, put it in their pocket?
No.
What does it mean that it's a pocket state?
So the only times that I was able to cause a pocket state to be recorded is when the camera was blocked and when the device received a phone call or was picked up in a particular way, so that the device thinks that you're about to try to use it. If the camera is not blocked from the outset, then nothing's recorded at all. And in order to get the pocket state cleared, the camera must be blocked to begin with. So again, you have to receive a phone call with it in your pocket and remove it in order to get a pocket state clear.
Okay, so have you noticed he's gone back to honesty? What he's saying is the truth, and his conversation flows. He doesn't have the disjointed cognitive overload, the indicators of deception. He's being honest and he's telling the truth. And it is fair and it is balanced. So let's not completely rag on the guy. He produced a fair and balanced, even report initially.
Thank you, because that helped me, because that's exactly where I was going with the next question, which is pocket state cleared. What did you conclude from 2937 to 2942 that it was in pocket state and then pocket state cleared?
There was some activity on the device that caused the pocket state to be checked. The device was in a pocket state up until 2942, when whatever was obstructing the camera was removed.
Next entry is a call at 12:29:44, and that you state is an incoming call from Jen McCabe, so there you do indicate the name, and you say answered 7 seconds, correct?
Correct.
Is the phone at this time that there's an incoming call from Jen McCabe that is answered out in front of 34 Fairview?
Yes, it would be according to the location data.
Right. So now we have at 12:29:44, the phone's out in front of 34 Fairview. There's an incoming call from Jen McCabe. It's answered. 7 seconds is how long the duration of the call was. Is that correct?
Correct.
And then 12.
So somebody has answered John's phone. It's either John or somebody else has it.
29:51, incoming call ends, and that's end of that 7 second duration.
Correct.
So you've concluded that this was a call that was indeed answered by the user of the phone, correct?
Correct.
Now let's go to Mr. Wolk 81, which is starting up at the top of 12:31:47. There is, as you indicate, an iMessage received from someone with a contact named Jen McCabe. You see that, sir?
I do.
Can you just state for the jury what an iMessage is?
An iMessage is essentially a text message sent primarily from iPhone to iPhone via the Apple servers, not like an SMS message which goes through carriers.
And is it correct that the message that was received from Jen McCabe said, from a contact of Jen McCabe, says, "Pull behind me"?
Correct.
And then at 12:31:52, we're back to Doppler pocket state, correct?
Correct.
Now let's go to the next entry, which is Deck 82. It's under health type. And what I want to do is see if we can clarify. The Commonwealth on direct examination, and multiple times referred to this as healthcare data. Do you remember hearing that healthcare data term?
I do.
Is that a correct term? Is it healthcare data or is it health data?
It's health data.
So it's incorrect to refer to this as healthcare data, correct?
Healthcare data is encompassed within Apple Health, but primarily if we're talking about steps being taken, it would just be health data.
Right, so the correct parlance is health data,
yes.
Correct? Particularly when we're getting to steps, is that correct?
Correct.
It's important to be precise about the parlance.
Yes.
So in this entry, 12:31:56, you state that there's the start of health event, quote, 36 steps / 25 meters, correct?
Correct.
Is it accurate to say that because we're in the United States and we don't work on the metric system, that 25 meters is about 84 feet. Are you able to make that calculation?
He's gonna check out the brain on Brad, isn't he, with the metric system?
It's approximately that, yeah.
Right. Would you accept approximately 84 feet? So as we discuss meters, we can go to feet and
Yes.
about 84
I would accept
feet.
approximately 3 times 25.
Right.
But
So, in your report of March 2025, isn't it correct that for this time you stated that the device began moving for a period of 20 seconds, correct?
yes.
So,
Okay, so don't forget, deception lives in confusion. John's phone is now moving. John's got out of the car. He's receiving texts. He's receiving phone calls. And now the phone is moving. Where's it moving to?
again, your conclusion from your analysis is, with these 36 steps, the device at this point began moving. Correct?
Yes, correct.
And don't forget, 36 steps. We don't know how many meters there are in a step, but it's estimated to be about 82 to 84 feet. That many steps.
Next entry. 123203. Pocket state cleared. Correct?
Correct.
So does that mean that there's some human activity going on, interaction with the phone, or not?
It could have been a received phone call. It could have been movement of the phone to be lifted.
But something has happened.
But something's
correct?
happened, yeah.
Next, 123204, device unlocked with Face ID. Correct?
Correct.
And then at 123205, it states application focus messages.
Yes.
Can you clarify what that means in terms of what is happening with the phone for the jury?
Yeah. So at 32 minutes and...
So at 32, Karen is meant to have gone, and according to the prosecution, John is meant to have been run into in reverse. But what's happening to John's phone?
5 seconds, the messages application was in focus on screen, so it was the application that was being used by the user at that time.
Now, the next entry is message 123206, and it states read message, quote, pull behind me, close quote, correct?
Correct.
Now, you don't indicate who that message is from in your timeline, but that's the message that was sent by Jennifer McCabe at 1231:47, correct?
Correct.
So whoever produced this PowerPoint, which is different than the report, has left Higgins, surprise, surprise, and McCabe, surprise, surprise, off.
Next entry is application lock at 123209, and you've got here end application focus, and then you state device lock with lock button for the last time, correct?
Correct.
So that's again pressing the side button on the iPhone that locks it.
Correct.
And that requires human conduct, human interaction with the phone, correct?
Correct.
And then the next entry under health data at 123216, that is 7 seconds after the lock. It's the end of the health event of 36 steps, 25 meters, and as we agreed, approximately 84
25
feet.
meters.
Correct?
Correct.
So, in terms of the steps, I want to turn to some further information with regard to your previous, the report that you mentioned on direct, which is the March 2025 report. Your Honor indicated a time for the break, and I'm going to go into a little bit of different area. Would you like me to keep continuing?
All right, Mr. Allessi. Folks, we'll stop. Turn the lights, please.
May I, Your Honor?
Yes.
Thank you. Morning, Mr. Whiffin.
Good morning.
And welcome back.
Thank you.
It's a new dawn, it's a new day.
May I approach, Your Honor?
Yes.
Thank you.
Thank you.
Looks like a nice day.
Mr. Whiffen, I just handed you, which is in evidence as Exhibit 43, and this is a portion of your March 2025 report. If you could just take a moment to look at it, and when you've had a fair opportunity to do that, I'd ask you to turn to page 28.
Okay.
And just, if you could, sir, just pick up your head and let me know when you're ready to proceed.
Okay, thank you. Thank you.
You ready, Mr. Whiffen?
I am.
Thank you. So, what I'd like to do is to, with Your Honor's permission, is to publish pages 28, 29, and 30, and start with page 28.
Okay.
Thank you, Your Honor. Mr. Wolf? And if you could enlarge the text down below as much as you can so the jury can see it. Thank you, Mr. Wolf. So, Mr. Whiffen, this summary section of your report is a summary of the location section that you wrote in your March 2025 report, correct?
That's correct.
And it states, the location data on this device contains a vast number of records while traveling between 12/19/33 and 12/24/38. These records all have a high horizontal accuracy value as well as bearing and speed information which conforms to the streets being traveled. Next paragraph. The device arrived outside 34 Fairview at 12/24/38 where it remained static for about 30 seconds. Do you see that, sir?
I do, yes.
And did I read that correctly?
You did.
Did I read that correctly?
Sorry, yes, you did.
Yeah, so at the end of it says, show the device moving west from the roadside towards the house. That's what you wrote, correct?
Correct.
I would like you to, Mr. Wilk, if we could switch back to the timeline of Mr. Whiffen that we had published yesterday in DEC. '79. Mr. Whiffen, if you could please, we just read that portion of your report that says at 25:30 the device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Did you put that in your time?
Okay, so remember, Ian Whiffen, he's written a fair, balanced, honest report. He says that John got out of the car and moved 84 feet westwards towards the house. That's what he wrote in his report. But then, at trial, once somebody in the DA has got hold of things, in my opinion, things change. Let's listen.
Timeline?
I did not.
It's kind of important information, isn't it?
I believe with the declining accuracy, the value that those records provided was more limited.
But it was important enough for you to write it in your report, but you didn't put it in the timeline. correct?
Correct.
Now if you could continue on your report, page 29, Mr. Wolk, if we could put, and we're going to be flipping back and forth between the timeline in your report.
Okay.
If we could go to page 29, enlarge it, the text, so the jury is able to read it along with us. We're going to start from the top. So the next says, from the combination of device location and bearing, it does appear that the device started to move towards the house. However, since the bearing information appears to be based on the location records rather than the direction the device is facing, it is difficult to say with any degree of certainty if the device actually moved. Did I read that correctly?
You did.
So the first part is again a statement that the device has started to move toward the house. Now if we could go to the next paragraph. This location data is immediately followed by 12 minutes of low accuracy records which offer no reliable location information. So I just want to make sure I've got the time period here right. The 12 minutes is from 12:25, correct?
Yes.
And so
correct.
12:25 plus 12 is 12:37. So the range we're talking about here is from 12:25 through 12:37, correct?
Correct.
Then, if we could go to, Mr. Wolk, please, back to the timeline, slide 82. So I want to discuss with you the very...
So bear in mind, the prosecution, the judge, and the witness are either going to demonstrate knowledge of the problem, knowledge of the danger of the truth coming out, or not. And it's going to be interesting whether or not you find that. All I will do is point out the words which are used, but then it's up to you to decide who knew what. Let's carry on.
Top entry, health 12/31/56, where you have the entry, start of health event, 36 steps, 25 meters, and yesterday we agreed 25 meters is approximately 84 feet, correct?
Correct.
And that is what you have in the timeline. Let's understand what that means. At that time period, 12/31/56, do you recall writing in your March 2025 report that the device began moving for a period of 20 seconds?
Related to the location data, I believe?
Yes.
Yes.
Now if we could, Mr. Wolk, go back to page 29 of the report. So what I want to do is go back to that paragraph up at the top, from the combination of the device. From the combination of device location and bearing, it does appear that the device started to move toward the house. However, since the bearing information appears based on the location records rather than the direction the device is facing, it is difficult to say with any degree of certainty if the device actually moved. So you're talking about difficulty saying with certainty, correct?
Correct.
But it is certainly possible that the device was at that location and was moving toward the house. That's possible, correct?
Based on location data, yes.
Now what I'd like to do, please, is to go, stay on that report, and the third paragraph says, the reason for such low accuracy location data at this time is not known, as there are many possible reasons why the accuracy was be reduced. There's a little grammar issue there, but
Correct.
In fairness to you, sir, we do that when we write long reports. But I think that your intention here is, you know, why the accuracy is reduced at this point, correct?
Yes. Correct.
Thank you. This could include reasons such as the device entered a building covered area, the result of weather conditions, geography, poor connectivity, or interference, to name a few. So those are the reasons you gave, which could contribute to some low accuracy, correct?
Correct.
And interesting, the very first reason you gave is that the device could be entering a building or covered area. And that phraseology could include a house, correct?
Correct.
It could include a garage attached to the house, correct?
Correct.
And it could include the house at 34 Fairview, and it could include the garage attached to the house at 34 Fairview, because both of those are buildings or covered areas, correct?
Correct.
Then you go on in the next paragraph.
So note, all of that is allowed. No objections. That's allowed.
To say it is known that the device was not being used at this time, and is this time that include that 12:37, 12-minute range, 12:25 to 12:37?
Yes, it was not being used for location purposes.
Right. So that's another reason why, right, the accuracy could be a little bit on the lower side.
Correct.
Now, the next paragraph says, at 12:38:13, when the device begins recording higher, and that's relative to what it was recording before. It's not that it's high, but it's higher than what it was just moments before.
Correct.
The data centers on a location slightly closer to the house than the roadside. Although several records show the same center coordinate with differing accuracy radii. Some of these location records are shown in the map below in white. So let's go down and look at what you had in your report for the area in white. In the area in white that you're referring to, there are two white circles, the largest one there. This, in fact, was a depiction that you included in your report.
So, don't forget, Brennan didn't put this report in. They put in a slideshow. And guess what the slideshow didn't have on it? This report showing that John's phone moved 84 feet away from the car, and during its journey it was doing things, including Face ID at one point, but then somehow, through magic, the phone makes its way all the way back and ends up under the body of John. What a miracle phone. It goes from the car all the way in, does things, and then wanders all the way out and puts itself under John's body like a loyal phone. It's ridiculous. Let's carry on. But more importantly, let's see what the judge and the prosecution do, because they won't like this.
On page 29, correct?
Correct.
Interesting and notable. you did not include that depiction in your timeline that you discussed with the jury yesterday, did you?
I did not know.
But it was important enough for you to put that depiction in your report, correct?
Correct.
And notably, the larger white circle covers a substantial amount of the house at 34 Fairview, correct?
Correct.
So, given your testimony on direct yesterday with Attorney Brennan, the phone of John O'Keefe, according to this depiction, could be anywhere within the largest white circle, correct?
Correct.
And this...
Okay, he's being honest. Do you remember his honest baseline at the beginning? When it's a simple question and the answer is in the affirmative, he can be honest this way. So he confirms to us, as the state's expert, that John's phone, through the evidence and that larger outer circle, could be inside number 34 Fairview. That's the evidence which he didn't present to the jury yesterday. And then it's your view as to whether or not Brennan and he did that on purpose. Did they deliberately leave out that fact?
Depiction was not offered by you or the Commonwealth in your presentation to the jury yesterday, correct?
Correct. Not in the PowerPoint.
Now,
the PowerPoint. This is the second time. Notice that the PowerPoint, not in the PowerPoint. Notice the passivity of the language. We have a change of language. So in goes the flag, the deception marker. The PowerPoint is sensitive.
If we could go back, Mr. Wolk, to page 29 of your report, into the text, and if we can enlarge the text just a little bit, please, for the jury, Mr. Wolk. So the paragraph that begins with at 12:38:13, when the device begins recording higher accuracy information. Again, the data centers on a location slightly closer to the house than the roadside, although several records show the same center coordinate with differing accuracy radii. Some of these location records are shown on the map in white below. And I repeated that just to...
So these are the sorts of areas where I struggle to concentrate. But this is where the evidence is. So a little bit of effort here and the case makes a lot more sense.
Tether to connect this part of the text to that diagram with the big white circle. Have I done that correctly?
Yes, correct.
Thank you, sir. The next paragraph. Over the next few hours, the GPS coordinate and the associated accuracy radius jumps around numerous times between the house and the road. Did I read that correctly?
Correct.
And therefore, over the next few hours, according to your report, the phone of John O'Keefe could be in the house, correct?
Based on the low accuracy information, yes.
The answer is yes.
Yes.
Okay, so we have slight distancing and slight justification and slight convincing language rather than conveying. So in go the flags. Remembering, of course, that individual flags mean nothing by themselves. So we're looking for clusters and superclusters. The judge so far has been reasonably quiet, hasn't she? Unusually so. However, we've got our notepads out and we're going to notice if she interferes at the dangerous points and if there's a pattern to her interference, and we're going to be doing this for the whole trial, by the way. We're going to see if that, but today we're going to see if there's a pattern to her interference which correlates directly with the danger of the truth coming out. How about that for a judge? Because so many people have a gut feeling that she's biased. But what we're going to do is show linguistically why they've got that gut feeling. We won't know, no matter how much evidence appears linguistically, whether it's just pure coincidence or not. Forensic linguistics won't tell us more than identifying the patterns. And then it's up to the person who views the patterns to determine what they think. They, of course, could ask an expert in forensic linguistics and statement analysis what they think, but it's only an opinion. The patterns, however, remain valid if they exist. Does that make sense? So in other words, the patterns, if we identify them, exist. Their meaning and their interpretation, that's down to you. So if you see the judge and the prosecutor and the witness all working together to justify why they've hidden the evidence from you, you could deduce a number of things. Coincidence. Obviously, in a contentious area of the trial, we're going to have increased objections and increased language from the judge. So there's lots of explanations, but if the pattern exists, we identify it, and then it's up to you to interpret. I hope that makes sense.
The next paragraph. Well, we'll stop there for a moment, and I would like to, Mr. Wolf, go down, scroll please, to that diagram that's right below that text again. Yesterday, you discussed the Waze application with Ms. Attorney Brennan, correct?
Correct.
And you stated that Waze location data is more accurate than the data that comes from the Apple apps like health data and location, correct?
Incorrect, no.
I'm sorry. Is Waze location data, in your view, accurate location data?
There isn't really a thing such as Waze location data.
I'm having trouble hearing.
Waze location data doesn't really exist. Waze is requesting location data from location services, and location services would respond with high accuracy information.
Okay, I appreciate that correction. So, when someone is using a Waze application, is the information they get through that Waze app accurate?
It tries to be accurate, yes.
And as a general matter, is the Waze application more accurate than the Apple information regarding location?
It's the same thing.
It's the same thing because it's coming essentially from the same source, correct?
Yes, Apple provides that information to Waze.
Right. So you had testified yesterday that at a certain point, the Waze application ceased functioning, correct?
Correct.
But just because it ceased functioning, the Waze, the Apple applications were still taking effect, and that's why you could make this depiction on this item that is on the screen now, correct?
Correct.
If we could, Mr. Wolk, go to page 30. What I'd like to highlight, please, is the text. So if we can enlarge it up at the top. So you then state, while location data from this data source, cache SQLite, is usually able to identify the location of the device with a high degree of accuracy and reliability, These records are so close that making a distinction between the device's actual location on the front garden is impossible. Correct?
Correct.
Your words, impossible.
Correct.
So in the report, he says impossible. Let's note that down. In the report, mind you, which Brennan didn't put into the trial. Bob Alessi had to put it in.
Did you provide any of the information in that paragraph in your timeline or to the jury in your direct testimony yesterday?
Not in the PowerPoint, no.
Not in the PowerPoint, no. So it's in the report that it's impossible, but in the PowerPoint, see the passivity? No. Anything exculpatory that proves Karen's innocence doesn't get shown to the jury. Not in the PowerPoint, no. Only in his report that Brennan didn't put in as evidence. Sneaky, eh? Sneaky. Let's carry on.
Next paragraph. If the location records are limited to just the record,
as we say in the UK, sneaky beaky. He's being sneaky beaky, is Brennan.
between 00:25, which is 12:25, and 6 a.m. and with an accuracy radius of 10 meters or less, there are 46 records, all of which fall within the red circle shown below. Go ahead, Mr. Woke, if you could scroll down. And that is the only depiction there that you included in your timeline yesterday, correct?
Correct.
So you took one of two depictions in your summary of the location, this one, in terms of your timeline presentation, correct?
Correct.
Now, in terms of the timeline, and Mr. Woke, if we could go back to the previous with the other depiction. It's on page 29. If we could enlarge that depiction, please. So, you testified that the flagpole in the fire hydrant are more down toward the small black circle. Is that correct?
That's my understanding, yes.
And yesterday, you rendered an opinion that you believed that the phone was mostly in the location by the flagpole in the fire hydrant, correct?
Objection.
I'm going to see counsel at sidebar for a minute, please.
Okay, this is extremely dangerous. Bev interferes. We're going to sidebar. The objection comes. Now she knows she has to overrule it. If she overrules it, Alessi's going to start attacking because he's an attack dog. He spends a long while getting to the point, setting up all the ducks in a row before he starts shooting them. And he's here. He's here now. We've waited this long. The judge knows it's exceedingly dangerous. Sidebar.
May I, Your Honor?
Yes.
Thank you.
The slight anger and annoyance and clipped tone of voice. Yes, came out from the judge there. I wonder what happened in the sidebar.
If we could dim the lights again, please. Thank you. So, if we can enlarge that depiction. So, yesterday, Mr. Whiffin, you...
By the way, did I say at the beginning that Bob Alessi is a really good boxer? Shouldn't be underestimated. I'd like to see him in the ring with Brian Albert, wouldn't you? I think I know who we'd all be cheering for.
Focused your testimony and your opinions on the smaller black circle, correct?
Correct.
And you didn't discuss at all or disclose at all this depiction, and therefore didn't discuss or disclose at all the larger white circle, correct?
Not when discussing my overall opinion.
Right.
Yeah.
So the answer is
no.
Right. So the fair way to interpret, and this is what you put in your report, this is your depiction, is that, and based upon what you said yesterday, the phone could be at the very edge of the top of the circle, correct?
Correct.
And the phone could also be at any point, so you can, in theory, put a phone anywhere around the very edges of that entire circle, correct?
There's caveats to that, but yes.
Well, I'm just asking
Yes.
you that according to your testimony yesterday in this depiction, the phone could be anywhere in that location,
yes,
within the area of that white circle.
Correct.
I would like to now go back to the timeline, Mr. Wolf, where we had left off.
And don't forget, not only can it be in the house, much to her absolute aghast that this is coming out, not only can it be in the house, but it's also doing things like answering itself and using Face ID. It's a magic phone, and eventually it's going to fly out of the house and bury itself under John's body. Like a puppy, loyal, come back to its owner. That's the magic of the prosecution phone.
Which is slide 82. And at the very top entry...
And so the people who are attempting to frame Karen Reid, they make so many errors. And they were drunk. They were all drunk as skunks anyway. So one of them decided, well, where should we put the phone? Oh, I know, tuck it under his body. It's just ridiculous.
You have health, time 31:56, and then the description, start of health event, 36 steps, 25 meters, and we agreed about 84 feet. And this is where the device began moving toward the house for a period of 20 seconds. Is that correct?
It's the time that 36 steps started to be recorded. I've got no idea of the direction of travel.
Well, that's not true.
I want to focus on the time.
In your report, you give a direction of travel towards the house.
12:31:56. Are you aware that a firm called Aperture, on behalf of the Commonwealth, has submitted a report that states that there was a trigger event at 12:31:56 that they refer to as the supposed collision? Are you aware of that?
Objection.
Sustained.
I recall seeing a report. Sorry.
You don't have to answer.
You don't have to answer that.
Sorry, apologies.
And that's okay.
Mr. Whiffin, are you familiar with a firm called Aperture?
I'm vaguely aware of them. I've heard of them once.
Okay, now listen very closely. I shall say this only once. The evidence Bob Alessi's ready. He's got. So if you've been patient and you followed along, you're about to be rewarded. Now watch this guy hedge. Watch his language change. Suddenly, Alessi has to drag the truth out of him like blood out of a stone. His language will become defensive, and his language will become full of hedging markers. And he will probably attempt to answer questions where in his mind he's rephrased it slightly. So he's not quite answering your question, he's answering another one. We're going to see clusters of deception flags. If you've got your notebooks out and you're following along in the membership, note down every single deceptive marker that you can see for practice.
Are you familiar with a person by the name of Dr. Judson Welcher?
I'm not, no.
But you're familiar with the firm Aperture?
I am.
And do you know that the Aperture firm is working on this case?
That's the only reason I'm aware of this company.
Right. And do you know that the Aperture firm...
Do you see? So we're starting to get, that's the, so at first it was very vague, hardly heard of them. Not really, can't quite recall. Who are they? I'm not really sure. Oh yes, no, I have heard of them, but only because they're working on this case. Do you see? I'm over egging it, but we're starting to get deception patterns. Suddenly, they spiked, they've increased. Did you notice?
Firm has used your data in your report. Do you know that?
I believe I saw something about that.
You believe?
I believe I saw something like that. So it's gone from hardly know them, it's very vague, it's very misty. Who? Oh yes, them. The only reason I know them is there's something to do with this case. A report, maybe, sort of something like that. Might have seen something like that. Can't really recall. That's where we're at. It's a pantomime. Now, yes, you know, I've acted a bit and over-egged it, but that's what we've heard. It'll carry on too. Listen.
You saw something, or do you know that they've used your data for a report in this matter?
I recall seeing a report. I don't recall whether it was my data that was being referenced.
Do you recall?
So suddenly this vague company that you've hardly ever heard of, now you have recollection of the report, but now you're not sure if it includes your own data. So he's gone from vague to detailed. Did you notice? Within the space of about 3 sentences, this is deception markers. This is him trying to hide the fact about how much he knows about Aperture, how much he knows about the differences in findings, how much he knows about what's been kept from the jury in their slideshow PowerPoint type report that only showed half of the photograph. Lo and behold, the half that helps them, and most of it, which proves that Karen couldn't have done it because she couldn't be in 2 places at the same time, and John's phone's doing all kind of weird magical stuff, same as their butt dial phones. Anyway, let him carry on. You'll see the deception yourself. You don't need me.
You're seeing a report from Aperture.
I do.
So you reviewed a report from Aperture.
Several months ago, yes.
And did you read the whole report?
It was a PowerPoint presentation, I believe.
Yes.
Yes, I reviewed it.
And you recall
you
reading
did.
that entire PowerPoint presentation?
I don't recall what it said, but I remember reading through it.
Fair enough.
Okay, so now this blood being extracted from this stone. Now he's read it. Do you remember he started off hardly know the company. Now he's read the report, but can't remember what he read. It's ridiculous.
Do you remember, as you sit here today, reading about a trigger of a number 11622? Do you recall reading that?
I recall seeing reference to a trigger event.
What did you...
Oh, so now hold on. You've told me just a second ago you've read it, but you can't recall any of it. Now you can recall a trigger event, can you? Do you see? we've got deception and Alessi squeezing the blood out of this stone.
You understand the aperture firm that's retained by the Commonwealth. What do you understand they meant by trigger 1162-2? Objection.
Sustained.
There's the tag team.
Do you recall the specific slide that discussed a trigger? Objection.
Do you recall that, Mr. Whiffen?
Very vaguely.
And this is another one of her little tactics that she uses. She interferes. She asks the question rather than sustained or overruled. She can't help herself. She interferes. And she goes a lot worse than that. Let's carry on.
Okay.
Would it help your record?
And then she said, okay. And then, did you hear her? Let's listen to that again.
2. Objection.
Sustained.
Do you recall the specific slide that discussed a trigger? Objection.
Do you?
Now, she should say overruled. But if she says overruled, the drip, drip, drip to the jury, the influence that she's attempting, becomes, if she keeps saying overruled, the jury start to infer things. So she keeps overruled to an absolute minimum and instead just asks the question again. It slightly takes the pressure off the witness too. This is a tactic of hers. So we note down the strategic, unusual interventions of the judge and when. And at what points in the trial do they increase significantly? And if we look at her body language and the change in language, the two combined, she gets extremely stressed, very nervous, angry when the truth is coming out. I believe, it's my opinion, that she is under instructions. And then the question is, who? Who is instructing this judge?
Call that, Mr. Whiffen?
Very vaguely.
Okay.
Would it help your recollection if I showed you a slide from that report that you said you reviewed to refresh your recollection? Again.
All right, so why don't I see counsel at sidebar? Bring
Now,
that
there's a huge danger of the truth coming out. Sidebar. Again. The danger of the truth coming out is so significant that she needs to put a stop to it. Let's carry on.
Mr. Alessi, please.
Mr. Whiffin, I'm handing you this. Excuse me, Mr. Brennan.
She's nervous as hell, look.
I'm handing you this document.
Thank you.
May I stand by the witness?
Sure.
We know she gets nervous because she keeps smashing her microphone with her monkey arms. She can't help it. She just starts flapping. That noise that you hear, this is her. Whenever she gets nervous, she starts smashing her microphone, twirling her glasses, spinning in her chair, calling a sidebar, interrupting. I mean, it's so obvious to me, but we're going to present the patterns and then you decide what you think about her.
Tell me when you've had a fair opportunity to take a look at that.
Okay.
Thank you.
She's nervous.
Mr. Whiffen, does that refresh your recollection with regard to an aperture report that discusses a trigger of 1162-2?
It does, thank you.
Pardon me?
It does, thank you.
And how does it refresh your recollection?
I remember seeing that several months ago.
I'm sorry, Your Honor. there's a blower on here that I'm having trouble hearing Mr. Whiffen. If you, sir, could bring the mic, it's not your fault. If you could bring it and speak a little louder, I'd appreciate it.
Yeah, I recall seeing that as part of the report that I read 2 months ago.
And you recall the time of 12:31.
So the jury's concentration will have broken. Alessi had got him on the ropes. He was absolutely smashing him. It had come out. Bev, Bourbon Bev, as she's known in some circles, recognizing the danger, interrupts the entire process for sidebar, giving this guy a break to resettle, to collect himself. At the same time, she would have put barriers in front of Alessi. We're going to hear these sidebars eventually in trial too. But that's where we're at. Alessi needs to get him back on the ropes ASAP. Let's see what he does.
38 now, correct?
Correct.
Let's go back to your timeline. 82. So you just spoke about a trigger 1162.2 associated with a time of 12:31:38, and we are now at the timeline of 12:31:56, correct?
Objection.
Sustained.
We are now going back to the timeline, deck 82, and you see up at the top where it says health 31:56. You see that, sir?
I do.
And then it says start of health event 36 steps, 25 meters, which we have said is 84 feet or so. And this is when the device begins moving, correct?
Correct.
And that is after the trigger of 1162.2, correct?
Objection.
Sustained.
Let's go to the next entry on the timeline, which is 12:32:03. You see that? That's Doppler.
I do.
And then you state pocket state cleared. Is the phone at that time in a pocket?
It's impossible for me to say. I can say that the camera was blocked, but I don't know what was blocking it.
You're saying at this point the camera is blocked?
It had been blocked, and at that point it became unblocked.
So at this point it became unblocked from a previous block status, correct?
Yes.
Does there have to be some human manipulation of the phone at 12:32:03 for that to happen?
Technically not. There are scenarios that wouldn't require it.
Is it more likely than not that there had to have been some human contact in action for this pocket state clearing event to occur?
Yes.
12:32.
But technically not. We could conjure up some magical way that the phone answers itself or comes out of a pocket. Do you see? Reticence. But then pressured for the honest answer says yes.
204 is the next. It's a type unlock. Device unlock with Face ID. You see that, sir?
I do.
Is there some human action that has to occur for the device to unlock with Face ID?
Typically, you must be paying attention to the phone.
Sorry, sir?
You must be paying attention to the phone, assuming that that setting's enabled.
So someone had to be looking at the phone.
Yes.
At 12:32:05, application focus. What does that mean?
That the messages application was at the foreground of the device being used.
Next entry, 12:32:06. We discussed this. It says read message, pull behind me, and that is associated with a Jen McCabe. It's the Jen McCabe message of 31:47, correct?
Correct.
And does a human have to be reading that for that entry to be made?
The message needs to be on screen. If the conversation with Jen McCabe was already on screen when the device was unlocked, then that message would automatically be considered read.
Next entry, app lock 123209, end application focuses messages, and then it says device locked with lock button for the last time. That requires human interaction with the phone, correct?
Correct.
And it actually requires somebody to take the cell phone and press the side button to do that, correct?
It does, yes.
I wonder
So
who
there
that
has to be
was.
some degree of coordination for that to occur, for a human to be able to have something that hits that button, correct?
Certainly, yes.
Do you understand what the term fine motor skill means? Do you
Yes.
understand that? And would that person have to be using fine motor skills to do that?
Yes.
So he couldn't be unconscious, dead in the snow, having been struck from a Lexus then, could he? If you need to be able to answer your phone and use Face ID and walk 84 feet with it into the house.
Next entry, 123216. End of health event, 36 steps, 25 meters, again 84 feet. That is in your timeline because that's when you believe the end of the health event, the end of the 36 steps occurred, correct?
That is the time that the device data shows the end of the health event, yes.
May I have a moment, Your Honor?
Yes.
Thank you. Do you recall writing in your March 2025 report the following? The final health activity of note on John's phone can be seen to have occurred between 12:31:56 and 12:32:16, during which 36 steps were recorded, covering a distance of 25.4 meters, again at 84 feet, according to healthdbsecure.db. Do you recall writing that?
I do.
And you used in your report 36 steps were recorded covering a distance of 25.4 meters or 84 feet, correct?
Correct.
Do you know?
So, how did John, if we're going to go with the prosecution theory, which is completely debunked anyway, but let's just go with it for a second. John gets hit by a vehicle. The phone flies through the air 84 feet to westwards towards the house, is what he wrote in his report. Then, during its travels, answers, uses Face ID, moves around for the next few hours, and then finally decides to plant itself back under John's body. This is the evidence. And this is the evidence they tried to hide from the jury yesterday. It's in his initial report, but not in the PowerPoint that somebody in the DA's office produced. Or did Whiffin produce the PowerPoint? Now, he used the word "the" with the PowerPoint, so he's seen it before. It's not a PowerPoint, as an example of the most simplistic of forensic linguistics. We know he's seen it before because he selected the article "the." Even the judge knows the importance of articles, the difference between a and the. But did he write the PowerPoint? You see, he doesn't have a motivation to frame Karen Reid. It's very unlikely that he would write a PowerPoint that showed 100% of the inculpatory evidence, showing Karen and the phone evidence in a light that the Commonwealth would like to present, 100% of that in the PowerPoint, and 0, in other words, the photograph cut in half, evidence proving her innocence. He wouldn't make that decision because he's got no motivation to frame Karen Reid. And yet it's what's happened. That's what the PowerPoint did. It cut the photograph in half. I believe his linguistics show this defensive nature because he's not happy to fully support the PowerPoint, inverted commas. He knows it should have included all his other findings, which he put in his original report, his report, which shows the truth to the degree that it does. Certainly a lot more bloody truth than the PowerPoint. It's not purposely deceptive in that sense. Let's carry on. And then we're going to go into the actual forensic linguistics itself after the we've only got about 10 more minutes to go. What I'll do is before, when I upload this video, I'll give you a timeline as to when the trial video stops and the analysis starts, in case you want to miss the trial transcript. However, I would recommend, if you have jumped to here, do invest in watching the trial, because it will help this report be understood so much more. But I understand time is of the essence too, so either or. I'll put the timestamp in for you. Now, where were we? Oh yes, let's go back to the trial.
A trooper named Nicholas Garino.
I'm aware of him, yes.
Are you a little more than aware of him? You've worked.
Okay, so we saw the pattern before, didn't we? On the report, where he's hardly heard of the company, doesn't really know them, not sure, very vague, very misty. Oh yes, no, I have heard of them, yes, but only because they wrote to report something to do with this trial, not sure which. Oh, a report, yes, I remember seeing something like that. Read it, yes, you're right, yes, I did read it, but can't remember anything that was in it. That bit, oh yes, I remember that bit. Now, are we going to see the same pantomime with regards to this guy who works in the police and has helped extract data? Let's listen. Let's
with
listen.
him on this case, haven't you?
I'll slightly rewind it so we know who it is, in case you weren't listening.
25.4
In case you were listening to me, Rabbit.
Correct.
Do you know a trooper named Nicholas Garino?
I'm aware of him, yes.
Are you a little more than aware of him? You've worked with him on this case, haven't you?
He sent me some of the files related to it, but further than...
I'm aware of him. He sent me some of the file. Oh, God. We're going to hear the same, aren't we? The hedging, the minimizing, the distancing, the passive language. In go the deception markers.
I've got no relationship with him.
But isn't someone sending you files on a case you're working on, working with the person? Isn't that a fair conclusion?
It could be.
It could be. Right. So what have we got this time? Now we've got, I hardly know him. Okay, he sends me some files. Well, isn't that working with him? It could be. This is evasion. This is deception. This is knowledge of it's a problem. What problem, I wonder? Let's find out.
Do you recall reading any reports of Nicholas Garino?
No.
I don't recall reading a report by Nick.
No. Ooh. What a now in poker, they call this a tell. Look what he's done. I hardly know him. Oh yes, I do know him a little bit. Yeah, he sent me some emails about the case, some reports. Don't really know him though. Not really. I don't think I've even read any of those. Oh yes, but I don't recall reading a report by Nick. It's no longer Trooper. Now it's his pal, Nick. Do you see the problem? He's gone from this complete evasion to Nick. He's given himself away. Let's listen again. Let's carry on.
Does that mean you didn't read it, or you just don't
Let's
work
listen
with
again.
him on this case, haven't you? So, a trooper named Nicholas Garino.
I'm aware of him, yes.
Are you a little more than aware of him? You've worked with him on this case, haven't you?
He sent me some of the files related to it, but further than that, I've got no relationship with him.
But isn't someone sending you files on a case you're working on, working with the person? Isn't that a fair conclusion?
It could be.
Do you recall reading any reports of Nicholas Garino?
I don't recall reading a report by Nick.
Does that mean you didn't read it, or you just don't recall reading it?
I honestly can't remember if I did or not. I remember some of the reports that I...
And did you notice the slight beg for the objection? Because he's been promised during the coaching sessions, don't worry, son, we're going to support you. Did you notice the slight beg? Many of the witnesses do it.
read for this case, I don't recall if one was by Nick.
Would it refresh your recollection if I showed you a portion of his report to determine whether you would have read it?
Please.
Thank you.
Sure. Yes. Show Mr. Brennan?
Yes. I just want to make sure I got the entire report. Mr. Whiffen?
Thank you.
And may I stand by the witness, Your Honor? Thank you. I am providing you with a document, and I would ask if that refreshes your recollection as to whether you've read a report of Mr. Garino.
A report or this report?
This report. Thank you, Your Honor.
That report is distant. This report is closer, more personal. The man you've seen before. A man, probably you haven't. Even the judge knows the importance of articles.
Okay.
However, she wouldn't know the extent of their importance from a forensic linguistic point of view. But she has a general knowledge that they're important.
I don't recall ever seeing this report.
This report. I don't recall ever seeing this report.
Have you ever had any conversations with Trooper Nicholas Garino?
Very briefly.
But you had, the answer is yes.
Yes.
Do you see? It's not just me, is it? Do you see? Very briefly. Everything's being minimized. Everything's being hedged. There's a problem here. There's a problem. What is it that they really need to hide? And believe you me, whenever somebody needs to really hide things, it's because they're worried about the truth coming out.
Did Trooper Garino tell you that he measured the distance from the flagpole to the front door and it was 72 feet? Did he ever tell you that? Object to the floor.
Sustained.
Did you ever have a conversation with Trooper Nick Garino about the distance from the flagpole to the front door of 34 Fairview?
Maybe.
Maybe.
Maybe. Guilt and shame.
Maybe.
So, is it maybe then?
And slight anger and defiance. Annoyance. Slight aggression. ever so slight coming out. He's been found out.
You had a conversation with him in which he stated to you that that distance is 72 feet?
It's maybe.
The ever so slight beg. The retreat to maybe again. The clown laugh because he knows it's ridiculous. The slight surrender to all I've got left is one more maybe. This is an indicator to Bob Alessi to push. He'll crumble on the next one.
So if we go back to what we were discussing earlier about the steps and the distance covered, and this is in your report of March 2025, where we've talked about this, and it's the final health activity of note on John's phone can be seen to have occurred between 12:31:56 and 12:32:16.
Is this the correct slide?
No, it's not.
So let's take it down.
Thank you, Your Honor. Let me start that over. The final health activity of note on John's phone could be seen to have occurred between 12:31:56 and 12:32:16, during which 36 steps were recorded, covering a distance of 5.4 meters, or 84 feet. 84 feet is greater than 72 feet, correct?
Correct.
So if the distance from the flagpole to the front of the house is 72 feet, and your report notes steps, 36 steps covering a distance of 84 feet, that would put those steps within the house, correct?
It would.
Let's continue on with the timeline. We now have Doppler 1233:14, and then Doppler pocket state. Do you recall in your report adding a word to this, that your report said pocket state detected? Do you recall writing that?
More than likely, yes.
Yes. But the detected word is not on that slide, is it?
It's not, no.
What does pocket state detected mean?
There was an active check by the Doppler function, and it detected that it was in a pocket state.
So that was removed on purpose by somebody on the PowerPoint. Anything which helps Karen, removed.
I would now like to change gears a bit and go to temperature with an iPhone. You recall.
But don't forget, it's like we don't know what's gone on in these sidebars. But don't forget, Alessi is treading carefully. He's not allowed to directly tell the jury, you know, what you and I are finding. He's having to be very, very subtle and hope they connect the dots.
That discussion in your direct testimony.
I do.
Thank you. Mr. Wilk, if we could please have the slide deck, but a different page, slide 60. And just tee it up, but please don't put it on the screen yet. iPhones don't record ambient or the environmental temperature where the phone may be at any given time, correct?
Correct.
But the iPhones, including the iPhone of John O'Keefe, log the temperature of the battery inside of it, correct?
Correct.
And as a result of that function, examiners and folks like you can use the battery temperature of an iPhone to identify increases or decreases in temperature within the environment that the...
Let's catch up now in the actual analysis itself. And let's do it in a couple of parts. Let's do first the evidence, what we've heard, what Ian Whiffen testified to, before we go on to analyze the actual linguistic patterns themselves. We must understand the evidence that makes those patterns significant. The expert witness, Ian Whiffen, testified about John O'Keefe's phone data. So let's find out in detail, by slowing down, what actually happened. Whiffin's timeline, what the expert told the jury. 12:24, phone arrives at 34 Fairview Road. At 24 and 59 seconds, the device is unlocked with a Face ID. 25:09, the device locked with a lock button. 29:44, Jen McCabe makes her first call to the telephone, and it's for a 7-second duration. It was answered by the user. At 31, a text message is received by Jen McCabe saying, "Pull behind me." 31:56, a health event is triggered, and we see approximately 84 feet of travel westward toward the house. It began moving for a period of 20 seconds. This is how long the phone took to walk towards 34 Fairview's entrance. Then at 32, the telephone, being in a dark place, in a pocket state, the expert testifies there had to have been some human contact in action for this pocket state clearing event to occur. In other words, you pick the telephone up and the screen comes alive, perhaps searching for either a pin or your face, however you've set it up. In this case, the device is unlocked with Face ID at 32. Hasn't Karen already left? Do put in the comments if Karen has already left in the Lexus according to that data. Because at 32, John's phone miraculously unlocks itself with his face. Then we have messages. The application was being used by the user. So, what the expert acknowledged these actions require: human contact in action. Yes. Do you remember he said for the phone to unlock with your face, paying attention to the phone, looking at the phone? Yes. Human interaction, yes. So Alessi very slowly, very methodically, for the jury, demonstrates that something is happening with John's telephone at 34 Fairview, and it's moving towards the house, 84 feet. But more importantly, what have they removed from the report and put into the PowerPoint? That's what we're really interested in. And then the aperture contradiction, where we see his language collapse into deception patterns. Are you aware that a firm called Aperture, on behalf of the Commonwealth, has submitted a report that states that there was a trigger event at 12:31:56 that they refer to as the supposed collision? I recall seeing a report. Not the report. I recall seeing a report. Distancing. minimizing. Blood out of a stone. Eventually, we get the admission. Two Commonwealth experts give two different times. The trigger event and the start of the health event. So there's a little 18-second gap. This is why it's sensitive. They're trying to hide from the jury that there's a problem. The timeline in detail. When we place all the evidence on one timeline, here's what emerges. The aperture trigger event, then 18 seconds later, a start of a health event. 84. The phone gets up after the accident and goes for a walk. 84 feet towards the house, westwards. The device began moving for 20 seconds. How incredible! Keep this away from the jury, otherwise the entire Commonwealth theory just collapses. So what do? They attempt to keep it away from the jury. Pocket state cleared. 3204. Unlock with the Face ID. Pull behind it. Jen sends her text. So what the evidence shows, if the aperture trigger event at 12:31:38 represents the collision, then 18 seconds later, the device, the phone, John's phone, begins moving 84 feet over a 20-second period. This is the evidence from the state's own witnesses. Their witnesses, not the defense's. It's just that the prosecution want to only show a little bit of their witness, not the bit that shows the truth and clears Karen. We don't want to show that bit because we're supposed to be framing her, don't forget. 25 seconds later, human contact. In other words, you have to have the ability to use your hands. Coordination. 25 seconds later, 26 seconds later, Face ID. 31 seconds later, that fine motor coordination is required again. The logical inference. If the prosecution theory is correct, John O'Keefe was struck by a vehicle at approximately 12:31 and 38 seconds. The strike rendered him unconscious, according to the prosecution, and incapacitated. He fell to the ground at the location where he was struck, having flown through the air. And he remained at that location, unable to move or interact. Then a miracle happens. In the same way that the same miracle happened to all of the suspects in the house's phones. They all suddenly started calling everyone. And they all started texting each other when they were fast asleep or making love. These telephones all became miraculous. Basically, they all got a life of their own. 12:32:03, pocket state cleared. The human action is required. And it's unexplainable, isn't it? If the person's unconscious on the ground, how can you explain this? You can't. So they have to keep it out of the trial. They have to keep it away from the jury. It's a problem. And you saw the linguistics change, didn't you? You saw the defensiveness suddenly rise. He knows it's a problem. I mean, it was almost funny, wasn't it? The way that he denied knowing the trooper and denied knowing the company. Oh, yes, I did read something, but can't remember anything about it. It's just ridiculous. All the witnesses are ridiculous. All the suspects are completely ridiculous with their lies on the stand. Anyway, so Alessi proves that the phone has got magical abilities, or the Commonwealth's theory cannot hold. A person cannot simultaneously be struck unconscious and incapacitated by a vehicle and performing the actions requiring consciousness, visual attention, and motor coordination. Now, Alessi, under strict rules, had to get this across to the jury. I think he did quite well based on how much Bev would have been restricting him, because God forbid the jury hear the truth about this. So between them, Alessi, I think, has done extremely well. He hasn't been able to present it as clearly as he would have wished to, but he's trying. So either the trigger event at 12:31 does not represent John being struck by a vehicle, or John was not incapacitated at that time, or someone else had possession of and was operating his phone. Do you think someone, having found the phone, put it to his face? Or do you think John hadn't been attacked yet? Either way, the phone has moved 84 feet into 34 Fairview, and we saw the circle of where that phone could have been kept, that white circle, do you remember, kept from the jury, and instead a different picture painted. Not the original report. That was kept out of the trial. Bob Alessi had to bring that in. Then we have additional timeline considerations. What else the testimony established? Movement before the phone actions. The health data shows the device began moving at 12:31:56, 18 seconds after the aperture trigger event. So the state can't have their cake and eat it. Which is it? Or if the state wants their cake and eat it, they have to explain how the Harry Potter phone suddenly starts flying everywhere, moving around and doing things. They can't. I wonder if the phone was lost for a period of time. You know, sort of, is it under the bloody thing? Is it in the snow? Where is it? Has it fallen under the sofa, or is it under the weights machine? Where's the bloody phone? Ring it. Text it. Did someone stupidly answer it? Did they then use it to put John's face against? Who knows? But we do know the state has got a problem, and they're trying to hide this problem from the jury. And we'll be looking at Cannoni's actions later on. For instance, could the phone be anywhere in that circle? It could. This is allowed. Could it be at the center point? It could. This is allowed. Could it still be in the car? It could. This is allowed. Could it be close to 34, inside 34 Fairview, for instance? Objection, sustained, blocked. The blocking pattern reveals awareness. It's okay to ask any questions provided you don't put that phone in the house. In fact, didn't Cannoni keep the house out of the trial in the same way that the Tully, Proctor and Buchanan stayed out of 34 Fairview? I think the reasons that Lank gave was he couldn't get past the foyer. Brian Albert was blocking it. Didn't Tully say that his reasons for not investigating inside 34 Fairview were Jen McCabe gave him information which meant he didn't have to. So here we have a suspect or in the cover-up of the killing or the murder in the house. So, well, the prosecution called it a murder, didn't they? So if the prosecution called it a murder, then it's a murder house. But Tully's reason is, no, I'm not going to investigate in the murder house because one of the witnesses told me I don't have to, because they gave me some information. His other excuse was for not getting a search warrant was he might get into trouble, but with whom is the question. And then his final excuse for not searching the forensics of a murder house is they didn't find the shoe until after 12, and by then it was obviously too late to actually search the murder house, which again is complete and utter rubbish. His three excuses for a non-investigation don't hold water. Anyway, I'm getting sidetracked. So we're going to look at the judge, and we're going to look at her forensic linguistics in detail, not just on Whiffin, but on every single witness. We're going to track what she's been doing, where she interferes, how she interferes, the frequency of her interfering, the excuses that she uses to interfere, etc., etc. So, but that might be for another day. Let's continue along with Whiffin's report for now. So where were we? I think we were boring each other to death, weren't we, on the telephone and the magic telephone. So if Karen Reid arrived home before these phone actions, now then, I think Loophole Lawyer has recently done a video that shows how fast Karen would have to drive to get home. But also it'd be interesting to put some cones out representing 34 Fairview's verge or curb, and get a professional stunt driver to reverse back following that curve at night and drunk, and not go up on the curve, but to follow it perfectly and then scream off home like a rally driver and get back to John O'Keefe's Wi-Fi signal in time to register getting home. And I think the maths of the drive show that it's possible if every red light and every stop junction, and she drove like a bat out of hell and made it. I think it's just about possible, but it's unlikely, isn't it? Or maybe Loophole Lawyer has proven that it's not possible. I'm not sure. I briefly saw it. Did you notice the hedging and the minimization there? So if Karen Reid arrived home before these phone actions, the Wi-Fi would stamp her arrival time. Let's look at that. Let's get in the comments when she actually arrived home. The travel time from 34 Fairview to 1 Meadows, let's find out what is that. And then let's work backwards. Even though Brennan and the prosecution are attempting to stop the evidence coming out, let's work backwards and see if the timings are possible. Not that we should, I mean, because we've got so much other evidence anyway. But I think proving the car once and for all might help those with cognitive dissonance to be more open-minded to the other evidence. You see, once you break the dam of someone that has believed something, like a woman scorned, remember that phrase? You know, once she sees through the boyfriend who she used to believe in and sees the truth, ooh, then she sees it all. And it's similar to when you've been, when you believe something and then years later you change your mind and then you see the evidence because you're willing to look. Until then, the human mind is designed to back up what you believe and to ignore evidence to the contrary. So, but when you break one piece of evidence beyond doubt to someone who really used to believe something, you can get the cascade. And then, well, you've seen people who see the truth for the first time. That, you know, There's some anger there, trauma, all sorts, which is another reason why the brain psychologically prevents this occurring. It's to stop the hurt. But anyway, maybe I'll do an entire VEROSCOPE analysis and report one day on cognitive dissonance in this case and why it exists. So what would this mean? If John's phone actions occurred after Karen left, phone cleared pocket state requires human contact after Karen left. The phone gets unlocked and Face's ID is used after Karen left. The phone button is pressed and requires fine motor skills after Karen has left. And the phone miraculously walks 84 feet inside 34 Fairview after Karen has left. All very inconvenient to the prosecution. If Karen arrived home before John's phone started performing these actions, requiring the human interaction, then the prosecution theory cannot explain who was actually interacting with John's phone. Was it John himself, or was it those involved in the cover-up? So the three possibilities: John was conscious and operating his own phone, someone else had John's phone and was operating it, or the timing of Karen's departure is different than the prosecution claims. So we have the prosecution theory versus phone data. The prosecution theory requires John O'Keefe to be struck by Karen Reed's vehicle at approximately 12:31, rendered unconscious and left in the snow at 34 Fairview. The phone data, as testified to by the Commonwealth's own expert, shows John O'Keefe's phone performing actions requiring human contact, visual attention, fine motor coordination. But what we observe, and we can't conclude, two Commonwealth experts provide different times. The 18-second gap between their times is problematic to them. We have multiple phone actions requiring human interaction occur after both times, and the expert testified these actions require contact, visual attention, coordination, and fine motor skills. What a problem for the prosecution. They've got to hide it. And so during the examination to the jury, the day before Bob Alessi's cross, that's what they did. They tried to hide this. The PowerPoint doesn't have the truth on it. It's been carefully selected. It's been curated. So, who made the PowerPoint? Was it the trooper? He was very sensitive about the trooper, wasn't he? I wonder if the trooper made the PowerPoint. So what we do not conclude, which expert's time is correct, what the trigger event is, whether John O'Keefe could or could not, these are not for us to conclude. We can only show what the evidence is. So let's have a look at some of the language used. The device is moving west, but this is omitted from the PowerPoint. This is in the report. This is not good to show the jury, so it gets removed on purpose, perhaps. Do you think the prosecution, a mob lawyer, they had to get a mob lawyer, didn't they? A mob lawyer might remove evidence that's inconvenient, mightn't he? What do you think? Let's look at the evidence. Isn't it correct that in your report that you mentioned in your direct, your March 25th report, that you had more of a description of what was happening at this time with the phone? Namely, device bearing shifts to a westerly direction as location records also show the device moving west from the roadside toward the house. Isn't that what you had in your report, Mr. Whiffin? Yes, that's covered in the location section of this report. And then we have a very unusual pattern arrive. He ends here, almost self-censorship, and he just states the PowerPoint. We have cognitive overload mixed with self-censorship, and then his brain, all it can do is just say what's sensitive and problematic and guilty conscious, the PowerPoint, because he knows the PowerPoint is not his fair and balanced, accurate report. Instead, this is curated to paint a picture and to leave out all of the exculpatory evidence. I wonder who made the PowerPoint. So, the question asks if phrases in the report aren't covered in location section, the PowerPoint. But the attorney did not ask if it's in the PowerPoint generally. He asked if specific language, device moving west towards the house, appears in the timeline shown to the jury. The response deflects to a different document location without answering whether the timeline contains this analysis. You'll notice with politicians, they don't answer the question either, and they slightly rephrase the question and then answer what they want, or more likely than not, give a speech instead of answering the question. Here, we see a similar pattern. Yes, that's covered in the location section of this report. Do you see how he's done a switcheroo? This report, the PowerPoint. You can't linguistically merge them and hope to get away with it. They're separate. This has the truth in it. This shows a tiny part of the evidence that you want to use to show a narrative and removes all of the exculpatory evidence which shows that Karen is innocent. And in my opinion, whoever is responsible for this, if they work in the DA, will have crossed the Brady line. In other words, you're not supposed to deliberately paint a picture to the jury which isn't the full picture on purpose, just because some people want to frame her. You're not allowed. You've got to play fair. You've got to seek the truth. Do you see how he's tried the little switcheroo here? This is all happening at the unconscious level. This isn't Ian Whiffen deliberately trying a switcheroo. This is the unconscious, knowing that these are different. This report, the PowerPoint, this is the problem. This is why we're getting the deceptive markers suddenly spike. You saw it yourself if you watched the trial transcript which we just played. You saw suddenly, as Alessi built up to the crescendo, the judge panicking, Brennan panicking, and the witness falling apart with deception patterns. It's not by mistake. Alessi knew, under the constraints he was under, and this is why he's a great lawyer to study. Under the constraints he was under, he still managed to get to a jury paying attention, the truth. But they had to be paying attention. These were the constraints he was under. There is no statement in this timeline under any type where you had concluded that at this time the record showed that the device was moving west from the roadside towards the house, correct? The location, latitude, longitude was moving westerly, but at the same time, the accuracy was increasing, so it didn't intrinsically prove the device was moving. Okay. Well, we were talking about that in your report, you concluded that it was moving west. And we see in your deceptive type of sentence, which for those who have been following VEROSCOPE will recognize this immediately in terms of its pattern, but you accept was moving westerly, but, and then you carry it, because this is inconvenient to them and therefore left out of the PowerPoint, only in the report. This report even, not the report. This is close. That is far away, if you want to remember. And even Canoni knew that there is a difference between this and that, and a report and that report. Even she knew. One day I'll tell you the biblical story of the wonderful example of statement analysis from King Solomon and the baby and the two mothers, and how he used forensic linguistics and statement analysis to separate the two mothers. And it's not what you think. It's not cutting the baby in half, although he did use that within his technique for finding out the truth. It was, I'll tell you very quickly, it was, one said, the dead child is hers, the live child is mine. And the other one said, no, 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 the live child is mine, the dead child is hers. And the order of social introduction is important. So King Solomon, in his wisdom, his gut feeling, said, the live child is mine, the dead child is hers. And the other one said, the dead child is hers, the live child is mine. Do you see how both women used a different order? One described the live child first, and one described the dead child first. So Solomon knew the real mother put the live child first in order of importance. And then to confirm it, he said, fine, we will cut the baby in half, divide the baby, and each mother can have her own half. And to confirm it, the real mother said, no, 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 she can have it. The false woman. And that confirmed Solomon's knowledge, and the real mother had her child back. Anyway, I was going to tell you another time, but I ended up telling you today. So, where were we? Where were we? Oh, yes. Whiffin is minimizing. Bob Alessi says, my question, Mr. Whiffin, is straightforward in this sense that I'm just looking for an answer of whether on this timeline you included the analysis that you had in your report that the device at this time was, transcript error. Do forgive my transcript errors. At this time was moving west from the roadside towards the house. Did you include it in that time line? No, says Whiffin, I left it out of the timeline. Surprise, surprise, surprise. Why did the brain require 3 asks before the direct answer? Second ask, third ask. The first response deflects to PowerPoint. The second response provides technical justification. And the third response, the direct admission only after repeated, increasingly specific questioning. We have the surrender. No, I left it out. But before, we had his gobbledygook. Do you see? So in statement analysis and forensic linguistics, we slow down and we recognize the gobbledygook. We recognize the second attempt at avoiding the question. And finally, we recognize the surrender and the truth. But then we ask ourselves, why is he playing the pantomime? Why are we having to go through this performance? Oh, well, that brings us to the end of the analysis.